Sagar, you may begin now.
Good afternoon, everyone. This is Advocate Sagar Rao, welcoming you all for today's webinar session by Honorable Justice Sanjeev Sachdeva, sir. It's my honor to introduce Advocate Vasantrao Patil Lawyers Training Center, which has been established by Sangli Bar Association with great support of senior and junior members of the bar. It's a unique center which has been established in the name of Advocate Vasantrao Patil, who was a renowned criminal practitioner at Sangli. He was also the president of Sangli Bar Association. Sangli Bar vigorously takes initiative for such activities wherein the members always support unconditionally. The training center was established with the purpose to boost the confidence in the budding as well as the practicing lawyers to impart knowledge, discipline, and overall personality development of the advocates, which is our motto. And in the past, we have held many such lectures to achieve the same. Thanking you all. Thanking you, Honorable Justice Sanjeev Sachdeva, sir, for joining us today. Now over to you, Ritesh Chavla, sir.
Thank you, Advocate Sagar. Hello, everyone. Today I am privileged to introduce the eminent personality from High Court of Delhi, Honorable Mr. Justice Sanjeev Sachdeva. Now, I would like to highlight some of the key achievements of Honorable Justice Sachdeva. Your Lordship holds an amazing academic record and obtained his degree from top-notch institutions. So I will start with his UG. He did his undergraduation from Delhi Public School, Mathura Road in Commerce in 1982, followed by his BCom honors from SRCC, which is one of the top-notch institution of University of Delhi for commerce programs. Then he obtained the Bachelor of Law degree in 1988 from Campus Law Centers, University of Delhi. He enrolled as an advocate with Bar Council of Delhi on 1st August 1988. He attended the Commonwealth Young Lawyers course in 1992 at the Institution of Advanced Legal Studies, University of London, and worked with solicitors and barristers in England as a part of the said course. He was qualified as an advocate on record of the Supreme Court of India in June 1995. I would like to highlight this that he trained as a lead trainer to impart training to advocates in advocacy skills involving examination and cross-examination of witnesses and also arguing of cases by the Indo-British Advocacy Skills Project. Trained various advocates of Delhi High Court, High Court of Jharkhand, High Court of Andhra Pradesh, High Court of Punjab and Haryana, and High Court of Manipur. He enrolled as an advocate on August 1st, 1988 with the Bar Council of Delhi and practiced in the Supreme Court of India, the High Court of Delhi, and the District Courts of Delhi. He enrolled as an advocate on record of the Supreme Court of India in 1995. He was the standing counsel for the Bar Council of India for the Supreme Court of India and the Delhi High Court over 20 years and appointed as a senior panel lawyer for the Union of India and represented the Union of India in various matters for over 10 years. He was designated as a senior advocate by the High Court of Delhi in July 2011. He was elevated as an additional judge of the High Court of Delhi with effect from 17th April 2013 and made as a permanent judge on 18th March 2015. Now, without taking much of time, I would like to invite Honorable Justice to start over the agenda for today. Sir, over to you.
Thank you, Mr. Chawla. It's a privilege to be here to talk on a subject which is very close to my heart, electronic evidence. You see, electronic evidence is a subject where everybody feels that probably it's something completely alien to them. But let me tell you, electronic evidence, like any other evidence, is available to you day in, day out. In today's day and age, when we are today using all kinds of gizmos and cyber equipment, we are generating huge amount of electronic evidence, which is available to all, and especially the prosecution agencies for bringing the criminal to book. Now, I'd like to show a little bit of presentation on electronic evidence. Electronic evidence. Electronic evidence is any probative information stored or transmitted in digital form that can be used at trial. Digital evidence is information of probative value that is stored or transmitted in binary form. Evidence is not only limited to that found on computers, but may also extend to include evidence on digital devices such as telecommunication or electronic media devices. For example, your cell phones, your cameras. Before any digital evidence can be accepted, it is of utmost importance to ascertain its relevance, veracity, authenticity, and also to establish if it is merely hearsay or if a copy is being produced instead of the original. Because today's day and age, it's very easy to copy documents, very easy to copy digital data. So one has to ascertain whether it is original or it's merely a copy which is being produced. Now, question is, how do you identify a computer? Every machine connected to the internet has a unique identification number, which is also called an IP Internet Protocol number. Your cell phones, your computers, your cameras, everything which has a microchip is in fact a machine which is like a computer and has a unique IP address. Be it a computer, a phone, your smart TV, your Xbox, your PlayStation, everything has a unique IP address.
So today I want to talk about IP addresses and what they mean. IP addresses are basically numbers that identify computers on a TCP/IP network. TCP/IP network is basically the most popular protocol for networking in the world right now, and it's how the internet works. And the IP address is the number that identifies your computer on the internet or on your local network. So even if you set up a home network with a router like this, or you're just going on the internet, you always have an IP address that tells you who you are in the network, so that other computers can relate to you, because computers talk to each other by numbers. An IP address is written down as 4 sets of numbers, not surpassing 255. So it'll look like 75.168.5.23, for example. And you basically have 2 kinds of IP addresses. Internal IP addresses that are used inside your home network or office network, and outside IP addresses that are used in the World Wide Web. Every website that you go to is basically a computer on the internet that has its own IP address. So when you're typing in google.com, what you're actually getting is a certain number associated with that name, which identifies that computer on the World Wide Network. If you want to know what your IP address is on the internet, there's actually a really simple way. Simply go to Google and just type in, "What's my IP?" There are many websites out there who would love to tell you what your public IP is so that other people can connect to you. So that's basically what an IP address is.
Now, why is an IP address important? IP address is important because that is the key to ascertaining who has used a particular machine. For example, if a computer is used in some cyber crime, then it will be the IP address which will be relevant to determine as to whether that system were used for any particular offense or not. Where will you find electronic evidence? It can be found in storage devices which could be built in, like in a cell phone or a computer hard disk, or external, like a hard disk, memory card, flash drive, pen drives. It can be found in digital files, emails, digital photographs, word processing documents, message histories, backup files. You name it and you have it. So entire electronic evidence can be found anywhere. Anywhere that, even for example, your routers, with which you connect to the internet. But the problem is, in the digital world, we are completely blind. The computers don't understand characters or alphabets. What they understand is zeros and ones. Zero actually means off and one means on. So it's electrical impulses by which the computers understand. So it's zeros and one which determine as to what you are or what is being informed to the computer. Now, to understand those zeros and one, the software by which it is written is very, very important. So if you have data on a computer, but you use an incorrect software to or an incorrect application to mine it, you'll never get a correct result. So even thumb impressions, fingerprints are stored in computers in zeros and ones. Now, if you use an incorrect software or an incorrect application to read something, then it will be jarbled like something like this, where it will not make sense, or something will appear like this. These are either errors or maybe an incorrect file has been opened with a different kind of software. A picture may look like this. Now, even we talked about digital signatures. Nowadays, it's very simple. Let's have a digital signature. Everybody should use a digital signature. Now, we use this kind of a software to sort of put in a digital signature on a document. Now, if I were to show you your physical signatures, say 10 years or 20 years down the line, you will be able to identify, yes, this is my signature. But do you know what your digital signature looks like? You have no idea what a digital signature is. This is actually a digital signature. Digital signature is this 256 characters, which are unique. Now, even a comma or a full stop change would change the digital signature. Now, if I were to show you this signature and say, can you identify whether it is yours or not? It will not be possible. In today's day and age, when you go and obtain a digital signature, you have to associate it with your email address. You have to provide your email address and they issue you a digital signature. Now, what if somebody uses your digital email address and obtains a digital signature and shows you a document that, look, this is a document which is signed by you. The only way to authenticate it is with your email address. Now, your email address would be correct, all your description would be correct, but you have never applied for that digital signature. If that is shown to you, there's no way of you to establish, yes, this was mine or this was not mine. You can't prove it because you don't know what your digital signature looks like, and it actually changes every 2 years. And when you apply for a digital signature, they don't even send a confirmation email to your email account that, look, a digital signature has been applied with your email address and it's been issued. The only way in which you can prove or disprove whether it was your digital signature is that small dongle which comes along with it. That's your private key. If you lose it, you can't prove what your signature was. And most of us just throw away these dongles. These dongles have to be stored forever because if somebody produces a document which is signed with a digital signature, the only way to prove that it is yours or it is not yours is with that private key. So please save that private key whenever you obtain a digital signature. Now, digital evidence can be classified as volatile or non-volatile. Volatile digital evidence is which remains in the digital media till it is powered. For example, if you switch on your phone and you're watching something, that will remain there so long as power is there. The moment you switch it off, it immediately goes away because it is something which is transferred onto your random access memory, the RAM. Non-volatile is one which always remains in the disk till it is erased. For example, in a hard disk pen drive, you put in data. It remains there even if the power is taken away. Before a court can accept digital evidence, it is of utmost importance to ascertain its relevance, veracity, authenticity, and to establish, in fact, if hearsay or a copy is preferred to original. Digital footprint. What is a digital footprint? Every time you access the internet, you leave a footprint. It's like footprints in the sand. And they're present all over the internet and they never get deleted. So be very careful in what you visit and what you do on the internet. because your digital footprint is available to everybody to access. And let me tell you, nothing you put on the digital file ever gets deleted. Digital evidence tends to be more voluminous, more difficult to destroy, easily modified, easily duplicated, potentially more expressive, and more readily available. Nothing put on the internet ever gets deleted physically. And it is also very difficult to erase a digital file. We all press that reformat button, we all put that in the recycle bin and feel that it's been deleted. It never gets deleted.
In life, you purchase your electronics, your groceries, your clothing, whatever else you need. You take off the packaging, you throw it in the trash can, and once a week someone comes to take it all away. It's like magic. Once it's gone, you never have to worry about it again. Unfortunately for us, the same cannot be said for deleting files on a computer storage drive. For one thing, usually deleting a file just moves it to the recycle bin, which has no sanitation technician who comes and removes it every week. It's simply a different folder location where files are stored indefinitely. The file is still there, and anyone with access to your computer can find them. Silly Linus, once it's in the bin, I can just empty the whole thing with one click, and my computer tells me, hey, this is a permanent change, and that file will no longer be accessible on your computer once you do that. And you would be correct mostly. The file is no longer easily accessible on your computer, but there is a huge difference between whether a file is easily accessible and whether it has actually been removed. On both magnetic and solid state drives, the bits of data that make up your photos, music, tax records, and whatever else are naturally kind of scattered around. And the way your operating system knows where to find all the pieces is, on NTFS formatted drives anyway, through the reference to it in the master file table. So back to deleting stuff. Removing a file from the recycle bin only removes the master file table reference that points to the pieces that make up that file puzzle and registers the space that it used to take up as empty. This gives the operating system permission to go right over it, but that does not mean that right after you clean out your recycle bin, the file is gone. Not by a long shot. In fact, there are many programs that are dedicated to reconstructing deleted files, some of which can do so even after a drive has been reformatted. And using those programs right away, like right after an accidental deletion or reformat before lots of the data has been gradually overwritten, has saved many a person's bacon from costly or upsetting loss of data. But sometimes you want to get rid of files permanently from a storage drive, like if you were going to sell it or donate it. In that case, how do you do it? Well, there are a few tried and true methods that we'll highlight today. The first one is to delete all the data on the drive, then fill it up to capacity with new random data over and over again. This method really wipes your whole drive, so make sure you have any important family pictures transferred to a new drive before you go ahead and do that. The second is physical destruction of the drive. Both fun and effective, but obviously you won't be able to donate that drive. That's more for if there's very sensitive data on it that you just need to get rid of. Speaking of things that are fun and effective, today's...
Now see, nothing put on the internet or on your computer ever gets deleted. Now, criminal activities relating to social networking. Evidence of criminal activity, social networks are increasingly becoming a source for discovery and in investigation of criminal activity by members. Profiles can be useful in determining the identity of or locating the perpetrator of a crime. For example, in this murder case, it was a blind murder case, and then they found a lead that the accused has got in touch with the victim over Facebook. Through the Facebook account, social media connection, they could then trace out the accused. Digital forensics. Now, that's a very important field as to where, if there is so much electronic evidence, what is the digital forensics doing about it? Computer forensics is a branch of forensic science pertaining to legal evidence found in computers and digital storage mediums. Computer forensics is also known as digital forensics. Goal of computer forensics is to explain the current state of a digital artifact. Term digital artifact can include computer system, storage medium, a hard disk or a CD-ROM, an electronic document, for example, an email or a JPEG image, or even a sequence of packets moving over a computer network.
Only on 7 News, for the first time a news camera allowed inside the Boulder County Forensic Lab for Computers, where we found the cat and mouse game of catching criminals is changing. 7 News reporter Amanda Cost revealing the new technology cracking cases and sealing convictions.
So this is off of a phone as it happens.
It's a case of he said, she said.
At this point, no one knew what was going on. Even the neighbors don't know what's going on. And in fact, when police arrived, they find her with blood on her face, and they thought initially she was the actual victim in this case.
Emily Cole was arrested, later convicted, but on trial claimed she was the victim.
But this, recorded off of the victim's cell phone 45 minutes before the event,
Someone's let you know I'm going to handle what I'm going to handle. I know where you live.
really demonstrates what she had intended to do.
It's digital evidence.
That's made all the difference in a lot of these cases that we prosecute.
Another example.
Circling the house.
Where GPS coordinates confirmed the stalker's route, and pictures of the child victim found on Luis Gutierrez's computer sealed his conviction.
All of that would have gone undetected because no one was there to see it.
Mom's ex-boyfriend was stalking the daughter, and a lot of the evidence found on his computer really helped in the prosecution of the case.
Discovered?
You see, today, all these electronic devices are mines and mines of electronic evidence and help sealing cases.
A girl kneeling.
Just mentioned about the child victim photograph which was recovered from his computer. Now, from the photograph, nothing was visible. All they could see was the child victim, but they couldn't identify the victim. See how that case was cracked.
A girl kneeling on a bathroom counter. To the unassisted eye, there's no way of identifying the person taking this photo, the perpetrator exploiting this young child.
We've got the pill bottle here. As I bring it up, you'll notice the more pixelated it gets.
Apart from the pharmacy and a first name Stephen, it's unreadable. This technology can change that.
So now we can see what the medication is and the first 2 characters of the prescription number.
That led detectives to this man, Stephen Keating, and they found another clue.
We had a close-up image of the suspect's hand.
By applying filters, they can bring out the detail.
It was actually the very first time that we were able to pull fingerprints from an image.
So this is really strong evidence to put this offender behind bars.
Absolutely.
And he is now serving time.
He's now serving a 110-year prison sentence.
And through...
Imagine, for a first time, they could extract fingerprints from a photograph by using filters. Amazing technology. Now, sometimes what happens is when you recover weapons or even bullet shells from the site, crime scene, the fingerprints are wiped off and it's not possible to then identify. This professor in England with only 500 pounds developed a system whereby you could extract fingerprints even from a bullet which is wiped off.
From an unassuming office in Northampton has come one of the most significant breakthroughs in forensic science for years. Dr. John Bond from Northamptonshire Police has developed a technique to uncover hidden fingerprints from bullets, even if they were wiped clean. It's quintessentially British. This cardboard box contains the prototype, developed for just £500 over 3 years. But it could help resolve thousands of murders around the world.
In the US, police forces have told us they have literally thousands of unsolved murders where a firearm's been discharged, shell casings like this one have been found at the crime scene, and conventionally they can't find fingerprints on the shell casing. So could we help? And we're very pleased to try and do so for them.
Dr. Bond realised that when someone handles a bullet, the sweat on their fingers will slightly corrode the metal. So even if a print is wiped off the casing, the corrosion remains. He's worked out how to recover that lost print. It's been named as one of the top inventions of the year and even mentioned on the hit show CSI. Now, Detective Tony Roten hopes it will help solve one of America's most notorious crimes.
Imagine from a cardboard box, you're able to develop a system whereby you can recover fingerprints even after they've been wiped clean. Now, another important feature of electronic evidence is metadata. Metadata is data that gives information about other data. Every digital file would also contain metadata about that file. For example, in a digital photo, as to which camera was used, what lens was used. In a file, as to the author, the number of characters, when created, when edited. Now, take for example this photograph. This is a photograph taken from a digital device, in fact, a phone. And this is a photograph of Shimla. Now, if this photograph were to be produced in court and someone were to say that I took it, say, 3 days back. Now, how does one prove or disprove it? It will be his word, and there'll be no way of ascertaining whether this photograph was taken 3 days back or maybe 3 months or maybe 3 years ago. Now, how do you ascertain it? If you look at the metadata of the photograph, you'll be able to find it out completely. Every digital image will have metadata about that image. Now, there are several softwares by which you can extract metadata. So I tried extracting metadata of this file, and what I found was that it contained the information that it was taken from an iPhone 7 Plus on 22nd of July 2017 and from the back camera of that phone. Now, question arose, what if I were to copy it from one place to the other? Will the metadata change? So I copied it. And after copying it, I found that the metadata remained the same. Again, same date, same number, and back camera. Now, I tried it with another camera. Now, this was another photograph which was taken just before you enter Leh and with a Samsung phone. So it has the detail Samsung GT19500, 16th of June 2016. And incidentally, this is actually the, 16th June 2016. Another software I've used to extract the metadata, so it has the model number. Another photograph, but with a different device. So that contains a Canon SLR, 16 June 2016, the firmware which was installed on the system, and also the lens and the serial number of the lens. That kind of information is captured. See, this contains the date, the model number, the manufacturer. So all these details are available on the digital data. Now, if you remember the first photograph, I edited it slightly, converted it into black and white, just to ascertain whether the data would change or not. And the metadata changed. It showed that it was taken with an iPhone 7, but Windows Photo Editor was used to edit it on 30th of July 2017, date and time. Incidentally, it retained the original date and time when the photograph was taken, as also the back camera. This is another photograph taken with another device, which is Sony, on 4th of June 2020 at 7:54 a.m. So every device, electronic device, which is used for taking a photograph, for recording something, will also record the metadata about that particular file. For example, this is a PPT presentation. This shows when it was last created, when last saved, how many paragraphs are there, how many word count, how many slides. And this is the metadata of a Word file. This shows when the content was created, when it was last saved, and when it was last printed. Now, you all must be aware of a thing called location services. What happens when you switch on your location service? Every time you switch on your location service on a phone and you take a picture, the phone creates a geotag along with the photograph. You go back to your photographs and you'll even be able to pinpoint it on the map where it was taken. This was a photograph taken in Srinagar, and when I was preparing the presentation, I actually went and saw that it had a geotag. It had a yeah. So this had a geotag, and when you blow it up, it showed that this photograph was taken at so-and-so location, and this is where the camera was placed. This was in fact the Lalit at that when it was taken. Now, what are you aware of spy files? Spy files are these files or malware which is put into your system. You may get a very innocuous looking mail from a bank or from PayPal or even from Apple saying your account has been disabled. Please re-enter your details, confirm it. Now, the first reaction we'll have is go ahead, log in. But in fact, if it's a spoof mail or a spy file which is being put, then it'll enter a malware into your system and all your data is then going to get compromised. For example, look at this. Now, this is a fake mail which has come. Your online banking account has been suspended. You need to confirm your access immediately. Log on so-and-so. Please never respond to these kind of mails and never log on these mails. Go back to the bank site and log on, because these contain incorrect information. For example, this is a spoof website from Amazon, which is a very correct looking screen, but see what they've done. They put an extra N. Instead of an L, they'll put an I. They'll put an extra A. And then it will contain a phishing link, whereby all your data will be then taken away. For example, in this Amazon Canada, there is A is missing, which you would not even notice. Now, these kind of links, these kind of spoofs are there to steal your data. Now, coming to data, we are all very concerned about Aadhaar. See what is happening in China.
识别的技术在2014年我们突破了人眼的识别准确率，那达到这么一个超过人的一个能力之后，它就有一个非常潜在的一个很大的一个市场可以去做应用。比如说，我们可以让机器去自动的判别。
预警阶段的话，我们会通过布在重点地方地区的这些摄像头，如果出现我们的公安的重点布控人员有出现，而且它的频率很高。
过这个人脸比对这个技术之后呢，我们觉得是大大提高了我们的工作的效率，大大提高了。
我认为呢，就是说人们在生活当中呢，既有安全的问题，也有隐私的问题。
And this system was recently used by them to identify corona patients. If they've traveled out, who have they met, who have they crossed on the street, even that kind of information was accessible through this. Now, do you know who's watching you? Google, Facebook, every time watches you. Everybody on their device, well, nearly everybody on their device uses Google. Google always watches you. Google knows exactly where you are at what point of time, where all you have traveled. It'll always keep an eye on you. For example, I came across this flight radar site which tracks every aircraft in the sky. Please go back to this site. Even now you will find flights, aircraft which are flying in the sky. It will give you data of what is the origin, where it is going, the flight path that it is taking, where it is taking, the height at which it is flying. All this information is available. We all use this application. Most of us use it to ascertain how much time it will take me, and it is fairly accurate. Now, do you have any idea how this is actually monitored? How does Google come up with blue, red, or orange in this application? It tracks every cell phone which is traveling from the point of origin to point of search that you put in, and then gives you that data. At what speed it is traveling, how many phones are traveling. Recently, a French artist tried this. It took several cell phones which were switched on.
Hello, Sanjeev sir. Hello.
I'm on call with Honorable Justice. He'll join in a moment. Actually, there's some technical issue.
Okay.
Yeah. Vikram, can I share the number with you on the chat so that in case you can connect with him? Viewers, just allow us for 5 minutes to restart the session.
Sir, you have to unmute.
Am I connected now?
Yes, sir, you are connected.
Shall we go back to?
Yes, sir. Please, sir.
Yeah. This individual thereafter took several cell phones and fooled Google Maps. Google Maps is turning from green to red even when the street is completely empty. And how he actually fooled Google.
So there is some disturbance with the mic.
Am I audible now?
No, sir. There is yet some disturbance.
There's a background noise.
The background noise is coming.
Background noise is actually my USB, UPS.
So you're not audible, sir, at all.
Yeah. All right, sir. UPS must be, so it's on the power bank.
That's the problem. Let me try and connect again.
Yeah, sir. Now it's fine. Fine, sir.
Okay, because probably it's taking too much. 1 second, I'll connect again. Can you hear me?
Yes, sir. Yes, sir. Clear.
Okay. Corporate espionage. Now we have this habit of checking in very often. We go to some place and suddenly check in. Imagine the entire family travels outstation and checks in from a 5-star hotel. We've all checked in at so-and-so place. And then their location, their Facebook friend knows that everybody is out of station. And they do what? Look at this. This was another issue of, this was a Bloomberg magazine which took out an article. This is photograph of a motherboard that one country put in a small microchip whereby they could hack the systems. And this is a device which is motherboard which is used from Amazon to Apple to US military. And they used this microchip to hack it. And this microchip was as big as the tip of a pencil. See, this tiny little device permitted bypassing of all security systems. And another thing which we always do is this.
बेटा आज घर पे अकेली हो क्या?
श्वेता मैम आज घर में अकेली हो ना?
दीदी आज अकेले हैं क्या?
अरे मैडम आज
discussing Tamasha.
Have you seen it?
हर एक फ्रेंड जरूरी नहीं होता है। सावधानी से अपनी जानकारी सोशल मीडिया पर अपलोड कीजिए। साइबर क्राइम को रोकिए।
Home alone tonight party. Innocuous post which he put on her Facebook. All her Facebook friends, which included the watchman, the liftman, a delivery boy, a maid, got to know that she was home alone. So be very careful in what information you share and what you put on Facebook. Now, coming to the Evidence Act, definition of evidence has been amended to include electronic records. Documentary evidence has been amended to include all documents, including electronic records produced for inspection by the court. Section 3 now defines evidence means and includes all statement which the court permits or requires to be made before it by witnesses in relation to matter of fact under inquiry. Such statements are called oral evidence. All documents, including electronic records produced for inspection of the court, such documents are called documentary evidence. Term electronic record has been given the same meaning as that assigned to it under the IT Act. It provides for data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microchip. Now, certain amendments have taken place in the Evidence Act, which have incorporated the provisions with regard to documentary or electronic evidence, electronic records. All these are now admissible as a physical document would be. There are certain amendments which have taken place in the IT Act. I did not go into all of them. But in fact, what they provide is that every electronic document virtually is to be treated like a physical document, has given the same weightage. An electronic record could be, as I explained earlier, a digital file. Now that will be an electronic record. 65B is a very talked about section. Several judgments on it, on the importance of how do you prove secondary electronic evidence. So conditions are computer output containing the information should have been produced by the computer during the period over which the computer was regularly used to store or process information for the purpose of any activities regularly carried on over the period by person having lawful control over the use of computer. Now, there are several requirements under section 65B. You have to give a certificate, you have to give an affidavit that this was normally used by the person. Affidavit has to be given by the individual who had control of it. Several questions though arise. What if you get an electronic data and person is not willing to give you that certificate? What if you want to prove something which is on Google server? Who will give the certificate? Those questions do arise. Now, certificate has to be produced giving particulars of the device involved, and that is where the metadata becomes very important. Because somebody gives a certificate saying that this electronic document has been generated from so-and-so system, and the metadata would actually confirm it. If you get the metadata, it'll confirm whether that statement is correct or incorrect. 65B stipulates several conditions. Some landmark judgments. State of Maharashtra, Praful Desai, this question involved whether a witness could be examined by means of video conferencing. This has become very relevant in today's context where everything is happening over video conferencing. Supreme Court observed that video conferencing is an advancement of science and technology. We permit seeing, hearing, and talking with someone who is not physically present, and with the same facility and ease as if they were physically present. If this was not possible, then we won't be having a webinar. We'll probably be locked into some hall having a seminar rather than a webinar. Now that's all become possible. And look at the foresight Supreme Court had way back in 2003. 17 years ago, it had this foresight that you don't need physical presence. You can have a virtual presence. Legal requirement for presence of a witness does not mean actual physical presence. Court allowed the examination of a witness through video conferencing and concluded that there is no reason why examination of a witness by video conferencing should not be an essential part of electronic evidence. Similarly, in Amitabh Bagchi versus Ina Bagchi, Calcutta High Court held that physical presence of person in court may not be required for purpose of adducing evidence, and same can be done through medium of video conferencing. Navjot Sandhu's case, appeal against conviction following the attack on Parliament, a very important case on cybercrime and electronic evidence. This case dealt with proof and admissibility of mobile telephone call records. While considering the appeal against the accused for attacking Parliament, a submission was made on behalf of the accused that no reliance could be placed on the mobile telephone call records because prosecution had failed to produce the relevant certificate under Section 65B. The court held that cross-examination of competent witness acquainted with the functioning of computer during the relevant time and the manner in which printouts of call were taken was sufficient to prove the calls. Then came Jagjit Singh versus State of Haryana, disqualification of a member of Legislative Assembly for defection. Supreme Court considered the digital evidence in the form of interview transcripts from certain TV channels and held that electronic evidence placed on record was admissible and upheld the reliance placed by the speaker on the recorded interview when reaching the conclusion that voices recorded on the CD were those of the person taking action. Supreme Court put the entire controversy on rest with regard to admissibility of an electronic evidence in Anwar PV versus BK Bashir. Supreme Court held that computer output is not admissible without compliance of Section 65B. It overruled the judgment in Navjot Sandhu. The statement of law on admissibility of electronic evidence pertaining to electronic record of this court does not lay down correct position and is required to be overruled. Judgment put to rest the controversies arising from conflicting judgments and provided a guideline regarding practice to be followed as to admissibility of electronic evidence. Stored data in CD, DVD, pen drive is not admissible without a certificate under 65B. In absence of certificate, oral evidence to prove existence of such electronic evidence and expert view under Section 45A Evidence Act could not be availed to prove authenticity thereof. Section 65B begins with a non-obstante clause would override the general law of secondary evidence under Section 63 and 65. So it mandated that there has to be a 65B certificate if you are producing secondary evidence and not primary evidence. This judgment has serious implication in all cases where the prosecution relies on electronic data and particularly in cases of anti-corruption, where reliance is primarily on audio-video recording which are produced in the form of CD. In all cases where CD and DVD are produced without a certificate under 65B, they would not be admissible in evidence, and even an expert opinion about their genuineness cannot be looked into. In Sanjay Singh Ramrao Chauhan, relying on the judgment in PV Anwar, while considering admissibility of a transcript or recorded conversation, the Supreme Court held that as the voice recorder had itself not been subjected to analysis, no reliance could be placed on the translated version of the transcript. Without the source, there can be no authenticity of translation. Source and authenticity are two key factors for electronic evidence. Abdul Rahman Kunji versus State of West Bengal, Calcutta High Court held that admissibility of email downloaded and printed from an email account can be proved by virtue of a Section 65B certificate. Testimony of witness to carry out such procedure to download and print the same is sufficient to prove electronic communication. Chhatrapal Singh Lodha and State versus State of NCT laid down that requirement of a 65B certificate arises only if secondary evidence is sought to be produced in place of original evidence. In case the original device and original media on which recording is made is produced, there is no requirement of a certificate under Section 65B. It is only where secondary evidence is sought to be tendered in evidence that a certificate under 65B is required. For example, if you produce the original cell phone or produce the memory chip on which the data is directly recorded, then that becomes the primary evidence and you don't need a 65B certificate. Supreme Court in Vikram Singh versus State of Punjab held that if electronic record is used as primary evidence, same is admissible in evidence without compliance with conditions of Section 65B. Similarly, in Union of India versus CDR Ravindra Desai, Supreme Court held that non-production of a certificate under Section 65B on an earlier occasion is a curable defect. Now, in Sonu versus State of Haryana, Supreme Court held that crucial test was whether defect could have been cured at the stage of marking the document. So what is relevant is the stage at which the document is tendered in evidence. If someone is tendering the evidence and producing the document in evidence, it's only at that stage that the court has to see that a 65B certificate is there or not. If it is not filed at the stage when the document is filed, it can be tendered at the stage when the document is tendered in evidence. Similarly, for example, in a criminal case, if certain electronic evidence or record is seized by the prosecution and produced at trial, then they need a certificate under 65B only at the stage when the witness steps into the witness box. Even up to the stage of framing of charge, they don't need a 65B certificate. The document can still be relied on by the court. Now, applying the test, it held that if an objection were taken to CDRs being marked without a certificate, court would have given the opportunity to the prosecution to rectify the defect. Similarly, in Karnataka Lokayukt Police Station, Supreme Court held that failure to produce a certificate under 65B4 at the stage when charge sheet was filed was fatal to prosecution. Need of production of a certificate, not fatal, would arise when electronic evidence is sought to be produced. No, it held that the High Court erred in coming to the conclusion that failure to produce a certificate was fatal. Need of production of such certificate would arise when the electronic record is sought to be produced in evidence at trial. It is at that stage that necessity of production of certificate would arise. The law of evidence in India has withstood the pressures and challenges of technology and cyber world. Amendments in evidence law incorporated by judicial pronouncements show proactivism. Law enforcement agencies have to update themselves about the authentication process regarding admissibility of electronic and digital evidence so that impediments in the trial procedure can be successfully overcome. This requires proper training of officers in handling cyber-related evidence and procedures for authentication and production thereof. Even lawyers, for that matter, require several issues they need to consider before they start handling electronic evidence. Well, you have to handle it in any case, but before you start tendering it, please acquaint yourself with the procedure, with the manner of ascertaining the authenticity, and then tender it in evidence. Thank you.
Your Lordship, thank you so much for such a detailed session. And I believe not only the advocates or the law students, but any person who has viewed this session would now have a detailed knowledge about how the foundation of an evidence comes into being. Further, my Lordship, you have not only touched upon the topic of evidence, you have also given us an insight about how the data infringement comes into being and how the electronic evidence plays a role. My Lordship, as our minds would be, and today in our situation of lockdown, electronic evidence plays a very important role. And even before we started the session, we had questions. And as we speak, there are a lot of questions pouring in. With your permission, my Lord, may I please proceed with asking you those questions?
Yes, go ahead, please.
Sir, the first question is from Advocate Mrs. Dake.
Imagine a lawyer questioning a judge. Anyways, go ahead.
This is a golden opportunity for me, sir. And I believe there's a lot many lawyers who have asked these questions. And
yes.
Thank you so much for this. Sir, so the first question is from Advocate Mrs. Dake, who is the public prosecutor from Sangli. And she has posed a situation first, wherein she says that a mobile was seized by the police, which has obscene messages sent from the accused to the informant. And this was produced before the court. First question would be, what is the nature of this evidence, sir? Is it primary or secondary?
If the original device is seized, then like I said earlier, that's primary. So you don't need a 65B certificate. 65B certificate is required. Supposing you were to extract the information from the device and copy it on a CD and produce the CD without producing the device, then that CD becomes secondary and then you need a 65B certificate. But if you produce the original device, then you don't need a certificate. That's primary evidence.
Correct, sir. Now, her second question is, like you rightly said, that if the device is seized, sir, can this device be shown as be shown by the prosecutor to the informant during examination in chief, sir?
You see, how will you prove a SMS or a obscene message unless you show it to the victim that, look, this is the message which was, and incidentally, she will have a copy of it, she or he will have a copy of that message on their device. Now, both will corroborate the material, and both devices will be original devices. The sender's device will be the original and the recipient's device will also be the original device. And both, if you produce both the devices or even one of them, that's sufficient to establish primary evidence without the necessity of a 65B certificate under secondary evidence.
But sir, in this case, he poses the question that how can, in a case where the defense contends or denies such kind of evidence, how will the evidence be proved? Now, you rightly said, sir, that there is a mobile phone and it establishes a primary evidence. But then what in this case, he denies to even own that cell phone, sir?
You see, first you'll have to establish the seizure of the cell phone from him. Having established that, then the question would arise whether you are able to prove what is the contents of that device or not. Because first and foremost, you have to establish the source, that yes, it was recovered from that individual, from the accused. If you're not able to establish it, then irrespective of whether you prove the contents is of no consequence.
Right, sir. So I believe this answers the questions for Mrs. Dake and Sagar. Sir, the next question is from Advocate Vijaya Ingule, and she asks, what is the procedure of presentation or objection of the electronic evidence produced under Section 65B in case of arbitral proceedings or quasi-judicial proceedings?
You see, arbitral proceedings primarily don't have to follow the formal rules of evidence.
Right.
So they can, even the arbitrators lay down the procedure because the arbitral tribunal has to determine its own procedure. It can even dispense with cross-examination and say that we will go on basis of documentary evidence without any oral evidence. So again, it's fluid. But if the arbitral tribunal decides to take evidence and follow the formal route of the Evidence Act, then 65B would become relevant. So if they make the Evidence Act applicable, then 65B would certainly be applicable. Otherwise, it's for them to determine the procedure and they can be fluid about it.
So this has a question. Like, I have a question in my mind when you say this stuff. So if this arbitral award gets challenged, or they suppose go in an appeal, and the court holds that they have not established this evidence correctly under the Act, what would happen in that case, sir? Would they have to contend the proceedings again, or
that won't be a ground under 34 to challenge, or would it be?
Right.
Procedural lapse may not be a ground under 34 to challenge, because court will then have to ascertain, depending on facts of each case, whether there is failure of justice or not. If there is no failure of justice, maybe because some procedure has not been followed correctly, may not be a good ground to set aside an arbitral award. So again, it will depend on facts and circumstances of each case.
Correct, sir. Now, the next question is from Advocate Vijay Taware, who is from Baramati. And he asks, when is the certificate for the electronic evidence mandatory to be submitted?
I've referred to several judgments which mandated that it must be produced at least at the stage when evidence is tendered. For example, when the witness steps into the witness box. You can file it with the document, you can file it later, but not later than when you're tendering the evidence. If you're tendering evidence and the court at that stage realizes that you don't have a Section 65B certificate, it can give you that opportunity to file it there and then tender that evidence.
Right, sir. So now we have this question from Advocate Arjun Pujari, who is from Karad, and he asks, what are the contents of an affidavit to prove the electronic evidence?
65B4 contains the details. It's there in one of the slides. I didn't go over it because it's part of the section. So just look at the section. It requires you what all details you have to mention in your affidavit, and that requirements are there in Section 65B4.
So I believe there have been multiple doubts solved in this session, but with your permission, sir, may I please even continue with a couple of more questions because there are quite a few number of questions. Thank you, sir. Sir, the next question is from Harsh Pathak, and he asks, what if physical evidence or electronic evidence differ in a case? What would the court prefer if there is a physical and electronic evidence both in a case?
You see, it will depend on facts and circumstances of each case. I can give you an example. There was a case where the allegation against an individual was, it was a case of a shooting. Somebody was shot. And the allegation was that I was held by person A and shot by person B. And it was his statement that I went to so-and-so place to meet a friend. That friend was not there, so I waited. That friend, it was a lady friend. She came back at so-and-so time, accompanied by two individuals. They didn't like my talking to her, so one of them held me, the other shot me. The shooting took place and he was injured in his thigh. They recovered the bullet, they recovered the weapon, and the girl also testified confirming what he had said, that so-and-so held him and so-and-so shot him. And the weapon was a licensed weapon of the one who was alleged to have shot this victim. Now, oral evidence is open and shut. It's a clear-cut case. Two witnesses saying you recover the weapon, you recover the bullet, and there is an injury. One of the persons who was alleged to have held him came up and said, I was just a mere bystander. I did nothing. I did not hold him. It's a false allegation. And incidentally, he produced a footage from a cell phone which was recorded by someone standing on the roof of one of the adjoining buildings, which showed that this person was simply standing. Two of them were fighting, one with the gun, one was the victim, going around a car. Then the victim goes and sits in his car, and the other person comes and shoots him. So what would you do in this situation? Will you follow the electronic evidence or will you follow the oral evidence? So this is a very odd example, because these are situations which will arise every day, and as a judge, you can't lay down a principle that I will prefer electronic to physical or vice versa. It depends on facts and circumstances of each case, what you would actually follow. So this was just an example to give you an illustration that at times oral evidence can be discredited by actual electronic evidence. And let me tell you, electronic evidence, unless tampered, does not lie.
Right, sir. So you adding in a practical example to this scenario even justifies the mentality of a judge while judging this. Sir, sir, can I proceed with last two questions, if you allow me, please?
Yes.
So this question is from Abhimanyu Chopra, and he asks, electronic information is so important, and whether Shafi Muhammad diluting the Anwar PV judgment is the new norm and applicability of Shafi Muhammad for civil matters, especially in the context of Section 65A and 65B.
You see, Shafi Muhammad does not actually dilute it. Anwar Bashir still holds the field. But like I said earlier, there are certain practical problems which occur. And you have to see practically how you are going to establish a particular document or secondary evidence. If you produce metadata, I have stressed specifically on metadata. If you are able to establish a document by metadata, then probably you don't even need a 65B certificate. Because metadata, if correctly established, will show the authenticity of the document and the veracity, and court will have to rely on it. But again, these are new fields where everybody's learning. We are all learning. And don't take it that I don't claim to know everything about electronic evidence. This is something we are all learning day in, day out. And with technology, there are several softwares which are available. I did not add that in my presentation. There are softwares which are available which can show whether an electronic document has been tampered with. If tampered, what is the editing done in it? So there are softwares available by which court and the forensic experts can establish the veracity of a document. So as we progress, You see, Anwar Bashir was again 6 years ago. As we progress, maybe new technologies will come, new devices will come where we won't even need a 65B certificate.
Right, sir. So this question is from Cyber RPS Jalgaon. I'm sorry, I do not know the name of this person. But then they have asked that when the detail is received from Google or Facebook, they do not provide 65B certificate for the details provided. In this case, how do we authenticate the evidence?
You see, if evidence, this is a challenge which is coming forward. For example, if you recover a CCTV footage or say a footage recorded by a third party, and he's not willing to come forward to give a 65B certificate, then what do? So these challenges do arise. Now, sometimes when it's a very crucial evidence and the court asks Google, they do authenticate documents, they do authenticate and provide information. But again, that may be in odd cases. In every case, they will not, of course, not come forward at the asking of an individual. These are challenges we are all facing, and simultaneously finding ways and means of establishing and proving the documents. The best sources produce the original. Then you don't need a 65B certificate. If you produce the original device, there's no difficulty at all. But again, if you ask a third party to provide you with a 65B, they may or may not. And most of the times they will refuse to provide it.
Right, sir. I believe this person who has asked it would have to research upon this topic and certainly on the cases where this has been adjudged. So there is also a question from Kishore Khilnani, and he asks, what in the cases that device has been destroyed after the crime?
You see, what happens is, as I showed you, that it is very difficult to delete data. Even if, say, you recover a cell phone or you recover a computer and it's been tampered with and it doesn't switch on, the memory card, the hard disk can always be cloned by the forensic experts and they can extract information therefrom. But if the device is completely lost, then you probably will not even have the secondary evidence. If the device is workable and you are able to generate a secondary evidence, then of course it can be produced and proved with a 65B certificate. But in the absence of the original device and the person who had possession and maintained that original device, the secondary evidence will be a very weak piece of evidence to be relied upon. Because electronic data is very easy to be tampered with and copied. And so with that caveat, one has to be very careful that if the secondary evidence is not being authenticated, then it'll be the judges would be very reluctant to rely upon secondary evidence.
So one final question. I'm really sorry for stretching it. This question is coming from Advocate Avinash Palkar, and he asks, nowadays there are applications to record incoming and outgoing calls, sir. I believe most of the Android phones now have this application inbuilt. What in these situations when these calls are there, and if these calls are misused, then how will these be proved? I mean, I believe, sir, you've emphasized correctly on the digital footprint existing online. But then again, we are coming back to the same circle on how do we prove these recordings, sir?
No,
and especially under electronic evidence.
You prove it by producing the original device. Then you don't need a 65B.
Correct, sir. But then he poses the question that what in the case, like it happened in the previous case, the device is not available, but the recording is available on cloud. And also his second question is, what about the voice recording? I mean, is there a way to determine whether the other person is who he claims it to be, sir?
You see, then you'll have to have the voice examined from forensic experts. They can actually break voices into different layers. It was again a surprise technique which I came across, that you can actually break layers of a voice. A voice has several layers, and they can break it into different layers and determine as to whether it is an individual's voice or it is been copied by someone else. So again,
right.
These are all challenges. We'll have to face them in whatever case they come up and how, in what manner they are being sought to be proved.
Right, sir. Sir, thank you so much for answering these questions. And I apologize for any inconvenience caused to you during this. I pass over to Advocate Priyanka Rane Patil for the vote of thanks. Thank you so much.
Thank you so much, sir, for a profound lecture. And thank you for sharing all the citations with us. It will help the budding lawyers at large. On behalf of Sangli Bar Association and Advocate Vasantrao Patil Legal Training Center, I would like to extend my sincere gratitude to you, sir, for the time and effort that you took to share your thoughts and experiences with the audience. Judging from the comments of those who attended the webinar, I must say, sir, has been very successful. And all credit goes to you, sir, for delivering such an insightful lecture. Since we are entering a new phase in the working of legal system, your comments are very timely. We sincerely hope that all of us can use your suggestions in dealing with the daunting task of navigating in this profession through these difficult times. Sir, we also hope that you would want to be involved in a legal training center program, and we earnestly hope to see you on this platform again and again. I once again thank you, sir, on behalf of the Sangli Bar Association, Advocate Vasantrao Patil Legal Training Center. I would also like to thank the office bearers of the Vasantrao Patil Legal Training Center. A special thank you to Advocate Sagar Rao, Professor Ritesh Chawla, and Pooja Khimani. I would also like to thank people who are working relentlessly in the backdrop, the technical team. I would also like to thank the people who attended the webinar. With your kind permission, sir, may I declare this webinar to have been concluded?
Thank you.
Yes, thank you, sir.